Welcome to Southwest Florida Real Estate Update, hosted by local realtors Jim, Michael, and Morgan York of the York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information on the local real estate market, featuring the leading experts in the real estate field.
Hi, and welcome to the Southwest Florida Real Estate Update. I'm Michael York of the York Real Estate Group, and today we're joined by our host, Jim York, and his guest, Don Ross Jr., President of Ross Title and Escrow.
Thank you, Michael, for the introduction. Well, Don,
Jim?
October 2018 here, and thank you for coming on the show this month again.
Well, thanks for having me, Jim. Really appreciate it.
Let's tell our viewers a little bit about yourself that haven't seen the show before.
Okay, I'm a local real estate attorney. I've been a member of the bar since 1982. I'm a shareholder in Downing Fry Realty, the attorney for that company, 30-odd years. I own Ross Title and Escrow. We've done somewhere 25,000, 30,000 closings. I have my own law firm. We have 7, 8 employees at the title company. My manager's been with me over 30 years, her daughter over 20 years, her sister over 10 years. So it's a family unit. We emphasize returning phone calls, being responsive, and hopefully do a pretty decent job.
Well, you do an excellent job. Our customers tell us that all the time, and you're part of our team.
Thank you.
So we have some questions that people have written in, okay?
Okay.
And the first question that this lady wrote in, she says, I'm selling my property, okay? And the buyer did an as-is contract.
Right.
And they've asked her to fix certain things within the 15 days, you know, like on the 14th day, this is what she's saying.
Okay.
And she didn't respond to the fixing the items because it was an as-is contract.
So the 15 days went by.
That's right. The 15 days went by. That's what she's saying. I'm trying to read this without my glasses. Okay.
How are you doing?
I'm doing good. So I know it's passed. Okay.
So
we've
they're passed
answered that question, but I
I'm-
thought it was a good question because I thought that maybe the real estate agent would have asked that.
She doesn't have to do a thing. The as-is NABOR contract and the FAR-BAR contract say that once you've gone by whatever the time period is, and in the NABOR, the default period is 15 days if you don't write in a different date. You know, sometimes folks put in a different date because they might be putting an addition on and they have to meet with the building department and architects and whatnot, and they need more time. But if you go beyond that time period, it says specifically in the paragraph that the failure to terminate shall constitute a waiver of the right to terminate. So there's no seller's response period. There's no opportunity for the buyer to cancel if you go beyond the 15 default day period and you fail to terminate. Now there's a method that I use with my customers, my clients, when they have something like this. And I've used it with my children. They've bought 9 houses among the 4 of them, and we always go with the as-is contract. We start early in the 15 days, and we ask nicely, you know, here's the inspection list, here's the estimates, would you mind fixing the water heater, the dishwasher, whatever it might be. And when they see the estimate and they see the inspection report, they know it's a real number, and they know you're not trying to ask for a credit for something that might be inflated, that you're trying to negotiate the price. And also, I coach the realtor to tell the listing agent that if you don't deal with this thing now, if it's significant, you're going to have to disclose it down the line. So if the roof is leaking, for example, or you have termites or toxic mold or something like that, the seller is going to have to disclose this to the next buyer. So one way or another, they're going to have to deal with it. So we start out nice, say day 5, and if they say no, then I have a conversation with my buyers and ask them, is this a deal breaker?
Right.
Okay, have you gotten estimates on how much it would cost to fix, let's say it's the dishwasher? Is it worth terminating the deal over a $500 dishwasher?
Right.
I mean, is the neighborhood good? Do you love the schools? I mean, overall, I mean, you're not buying a brand new house. Overall, is this worth it? If it's a deal breaker thing, and I get those, I had one where a lady had breast cancer and they had radon. And she just didn't want it.
Right.
So sometimes it's just, there's no way that they're going to accept it. It's too much. The damage is too extensive. They don't want to deal with it. And in that case, we write a letter to the seller saying, you either fix this, and you give them the inspection report showing that's real, or give us a credit for this, and give them an estimate showing it's a real number, or we hereby terminate. That way you don't run the risk that's going to run past the 15 days
Right.
and give up your rights. Because again, the clause says that this is a waiver if you go beyond the 15 days. So you make it a conditional request. We either get the credit, or you agree to fix this, or we hereby terminate.
Terminate.
And what I tell the agents, or the buyers, whoever it might be, call the other person to make sure they got the email. Because
Right.
it gets caught in spam folders.
Exactly, it
People
does.
will say they didn't get it. You make a little note in your file that you spoke to whoever it is and that they got it, because you don't want to have that issue in terminating the contract. Now, sometimes, they'll make this request and they might have $1,000 down.
Mm-hmm.
Nobody's going to buy a property just because they have $1,000 down. If they have significant inspection issues,
Right.
sometimes the seller says, well, it's not fair and it's not really a problem, and they may be right.
Right.
But the bottom line is the seller doesn't have too much leverage against the buyer because there's only $1,000 down, and under NABOR, all the seller can do is go after the $1,000. Under FARBAR, if they don't terminate, they can go after the $1,000 plus whatever the second deposit might be. So you start out nice
Right.
in the beginning.
Work your way in.
It's always good to be nice first.
That's right, it is.
And then if it's a deal breaker item, we can write the letter that I just described.
So let's explain to our viewers a little bit. That's our as-is contract.
Right.
What's the difference between that and a regular contract? Because
Well,
the response period and
The,
stuff like that.
the regular contract, you have 15 days, this is NABOR again.
That's right.
15 days to do your inspection, the buyer does.
Mhm.
It's non-invasive, they can't go ripping sheetrock off the wall or
Right.
anything. And then they have 5 days to make a request of the seller. Why? Well, if you have an inspection on the 15th day, it might take a day or two to have it typed up,
Mhm.
because you're supposed to give a copy of the report to the seller.
Right.
Seller needs to see that it's real. If they're asking for a credit, they have to give an estimate. Make sure it's real. They can't pick round numbers like 5,000,
Mhm.
10,000. It's got to be a real number.
Right.
So 15 days for inspections, 5 days to ask for whatever it is. It's defective under the contract.
Mhm.
And then the seller has 10 days to respond. Now, why? I mean, why so much time? Well, sometimes the inspectors just don't know how to turn on whatever it is.
That's
They
right.
don't know how to turn on the hot tub. They can't find the switch. Sometimes the seller wants to get their own inspector out there to see if they agree with the buyer's inspector. Sometimes the seller wants to get their own estimate,
Right.
because there's a wide range of estimates you can get, say, for mold.
Right.
They don't take for granted that the contract doesn't specifically say in the regular contract whose estimate and whose inspection report will control. The seller needs time to respond, to figure it out, and to analyze it. And if the seller says no to something that's clearly considered a defect under the contract, like the roof is leaking,
Right.
the buyer has 5 days to cancel and get their deposit back. And we have a form, our handy-dandy buyer's election seller's response form, where the seller can check off, what they want, whether they want certain things fixed, whether they want to credit how much, and they attach again the inspection report and the estimates. And then the seller has a place where they can accept, deny, or counter.
Counter.
And if the seller says no, there's a little note down here, the buyer has 5 days to cancel. Now, what I see with this form a lot is that it's used with the as-is contract,
Mhm.
which is, in my opinion, malpractice.
Exactly.
Because it creates the impression
Right.
with buyers that the seller has a period to respond and that they have 5 days to cancel.
And that's what
And
this.
they don't.
Right, they don't.
They absolutely do not.
Right.
Once the 15 days is up, assuming that's what it is,
Right.
that's all they get.
Right.
So this particular form is strictly for the regular NABOR contract, not the as-is contract, not the FARBAR contract, because that has different rules.
That's right, exactly. Well, I think that answered, and I think that's where a lot of the confusion came in with this.
I see it all the
with
time.
people.
I mean, it's a little scary.
The next question I have is this seller had multiple offers, okay, and they were presented to the realtor, kept sending them the multiple offers within this day period.
Right.
And they didn't know how to respond to all these multiple offers. So I know this is passed, so this is just explained to people in the future. Hopefully we have multiple offers.
Well, it's a great problem to have.
Right.
Yeah, I'd love
If
to
you're
have
a
multiple
seller,
offers
right.
any day of the week. It'd be great. You know, I try to use metaphors as much as possible. You want to play hard to get.
Right.
Yeah, you know, you're back in high school and you're at the high school dance, and you know, you play hard to get.
Right.
You know, if you seem overly eager to sell, you know, buyers sense that. The National Association of Realtors, they have an ethics and arbitration manual, and they have several pages on multiple offers in different ways to handle it. Well, the important thing for Jim York or any other realtor, or Don Ross for that matter, is I submit all offers to the owner.
That's right.
Even after the contract's signed. That's case law in this state. So you want proof that you submitted all offers, because the other agents are going to think that you didn't submit theirs.
Right.
If you found a buyer and yours got accepted rather than theirs.
Right.
So it's good to show that you submitted all of them. And then the seller will ask you, what do I do? And I always ask, well, do you need the money? I mean, do you need this to buy some other property?
Right.
You know, if they're wealthy people, do you care? You know, if this falls through or not. A lot of them don't. And if they don't really care whether it goes through or not, one common thing that we do is we just give people a deadline and say, we have multiple offers. You got to check your listing agreement, by the way, to make sure that you're allowed to say that, because there's a block you check in the listing agreement. But you know, I end up telling the buyers, we have multiple offers. Make your best offer by 5 p.m. tomorrow, or whatever my client says. And you know, occasionally, you know, if it's a high-end property, I'll say, my client really doesn't care, and they often don't. And that's the best position to be in. They don't care. So you make the best offer. You get it at 5. If you have any counter offers out there, counter offers are generally good for 2 days under these contracts.
Right.
You got to make sure you've revoked the counter offer before you sign the one you want to accept. And again, call the other person, the other realtor that you're revoking the counter offer from, and say, did you get my revocation?
Right.
Just make a little note so that they don't still have a window to have 2 accepted contracts.
Right.
So if you don't revoke the counteroffer, some people lose track of that 2 days. If you don't revoke that before you accept, you're in trouble. Plus, by making the phone call to make sure they get it, you can sort of gauge the emotional reaction of the disappointed realtor. You know, my client's a litigator from New York, and they're gonna sue. So you know all that stuff.
Right.
You know, versus just shooting in the email. So it's always good to call for both those reasons.
Well, I think we've answered those 2 questions, and I think we're going to end the show, and we're going to come back with part 2 in another show, okay?
All right, great.
Thank you very much.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Looking for a real estate closing agent in Southwest Florida? Ross Title and Escrow has over 25 years experience and has closed over 20,000 residential real estate transactions. Donald Ross Jr., president of Ross Title and Escrow and a practicing attorney in the state of Florida with a degree in taxation, is here to service your needs. Call Mr. Ross or one of our 4 closing agents for a free consultation today.